Good afternoon, friend. This is Mrityunjay Shekhar from Mrityunjay Shekhar and Associates. Now we are talking on a new topic, that is fast track merger. All of you know, under the Companies Act section 233, it has been incorporated. This is a new era, simply fast within deadline. Timeline is 60 days maximum from the date of filing application to the RD. MCA has notified it on 15th day of June 2023. So the application filed thereafter shall be considered and taken under the said rule. It is not a new timeline, but this notification mandated timeline of 60 days to conclude the fast track merger application filed before the central government, that is the regional director. The process and procedure of fast track merger and intent of the government is very clear that unnecessary delays should be avoided. It is a new step to bind the process with definite deadlines. In case of delays, the application shall be deemed that it has no objection to the scheme and a confirmation order shall be issued accordingly. The ROC, the Registrar of Companies, and OL, official liquidator, has been allotted 30 days time line to revert with objection or suggestion from the receipt of copy of a scheme only. So there is definite timeline of 30 days. They will have to revert. If the central government is of the opinion that the scheme is in public interest or in the interest of creditor, it may within a period of 15 days after the expiry of said 30 days issue a confirmation order of such a scheme of merger or amalgamation in form number CAA 12. In case the objection or suggestion has not been received by the ROCOL, it shall be deemed it has a no objection to the scheme and a confirmation order shall be issued accordingly. Where objections or suggestions are received within a period of 30 days and are not sustainable, and the central government is of the opinion that the scheme is in the public interest or in the interest of creditor, it may within a period of 30 days issue a confirmation order of such a scheme of merger or amalgamation in form number CAA 12. But if the central government is of the opinion, whether on the basis of such objections or otherwise, that the scheme is not in the public interest or in the interest of creditor, it may within 60 days file an application before the tribunal in form number CAA 13 stating the objection or opinion and requesting that tribunal may consider the scheme under section 232 of the Act. So if we will see, timelines, ROC and OL, timeline is 30 days to submit objection or suggestions. RD, 30 plus 15 days, no objection and suggestions received from the ROCOL, confirmation order CAA 12. RD, 30 plus 30 days, objection and suggestion received from the ROCOL but not sustainable, confirmation order CAA 12. RD, again 30 plus 30 days, objection suggestion received from ROCOL, sustainable, application before the tribunal, form number CAA 13. For limited class of companies, a scheme of merger under section 233 of the Act, read with rule CA 2016, may be entered into between any of the following class of companies, namely merger between two or small companies, merger between two or more small companies. First, merger between holding and its wholly owned subsidiary company, two or more startup companies, one or more startup company with one or more small company. For the purpose of this sub rule, startup company means a private company incorporated under the Companies Act 13, Companies Act 1956, and recognized as such in accordance with notification dated 19th February 2019 issued by the Department of Promotion of Industry and Internal Trade, that is DIPP. Small company. What is small company? Small company means a company other than a public company under Section 285 of the Act. A paid up share capital equal to or below 4 crore or such a higher amount specified not exceeding more than rupees 10 crore. A turnover equals to or below 40 crore or such higher amount specified not exceeding more than 100 crore. This mechanism offers a cost effective solution with no involvement of National Company Law Tribunal, no requirement of special audit, no administrative formalities. The process does not require any newspaper advertisement or public advertisement announcing the merger. Steps. What are the important steps? First is transferor and transferee company. The notice inviting objections from ROC in form number CAA 9. Second, form number GNL2, transferor and transferee company. The declaration of solvency in form number CAA 10. Transferor and transferee company will file MGT 14, board resolution and special resolution passed for approving the scheme. Third is transferee company GNL1, filing of scheme form number CA 11 with the regional director. Transferee company again RD1, reporting of meeting in form number CA 11. Transferor and transferee company confirmation order to be filed with the ROC INC 28 once the approval is granted. First is board approval of the scheme. The draft scheme requires approval of the board of directors of both companies. 90% of shareholder in number and 90% of creditor in value. A notice of proposed scheme shall be sent by both transferor and transferee companies to the ROC and official liquidator where the registered office of the respective companies are situated or persons affected by the scheme, inviting their objections or suggestions on the proposed scheme. The said notice shall be in form number CAA 9. Within 30 days of the issue of the notice of the proposed scheme, the ROC and OL shall provide their objections and suggestions, if any, which has been explained above. Filing of declaration of solvency by both the transferor and transferee company to the registrar of company in form number CA 10. Shareholder meeting, creditor meeting with a 21st days notice, clear notice. Filing of application with regional director, copy to ROCOL within 7 days post meeting of shareholder and creditor. Report by the ROCOL within 30 days. Order from RD within 15 days if report has not been issued by the ROCOL, or 30 days if it has been issued and good to go. If there is any objection from RD, it shall be referred to the NCLT. Thus total 60 days only. Complete. This is a new era, simply fast, within deadline. Thanks.